We'll let folks sign on that maybe we are trying to. We'll give them a minute, and then we'll get rolling. Okay, let's call to order the Stakeholder Advisory Committee group discussion for Friday, September 9th, 2022. Welcome, everyone. As you know, we've had a series of these extra meetings along the way that are very topical in nature and specific in nature to those topics. We had a request at our last full SAC meeting to get a perspective from the Public Defender's Office. So that's why we're here today. We have three folks with us today from the Public Defender's Office. We have Stark Paulus, who is the Director of the Whatcom County Public Defender's Office. We have Maya Lisa Vano. She's the Chief Deputy for the Whatcom County Public Defender. And we have Jane Bowman, who is a Senior Deputy Public Defender for the Whatcom County Public Defender's Office. So what we'll do now, without any further ado, is we will turn it over to Stark and let you lead us through the day. Stark, so go ahead, please. You're on mute.
You think after 3 years I would have this zoomed down, wouldn't you? Okay, what I said was thanks, everybody. It's nice to know that folks are interested in the Public Defender's Office, and I'm going to try and provide a little bit of background to the office before we launch right in, so that you are up to speed on who we are. We're located across the street from the Bellingham Public Library, and currently have 23 lawyers on board and about 8 legal assistants, 6 investigators, and 2 behavioral health specialists. On any given day, we have numbers in this building approaching about 50 employees. So we've gotten quite large from our inception back in 1982. We handle somewhere in the neighborhood of 15 to 1,600 felonies a year. We handle somewhere in the neighborhood of 2,000 misdemeanor cases a year. These are all cases in the county courts, and most of the sanctions that are doled out to our clients, if they're convicted, involve the county jail, which I guess makes us topical to the committee's discussions. Our present situation is sort of difficult at the felony level in particular, because our numbers have really continued to rise and are rising faster than the office is growing. Frankly, we've taken in, as of the end of July this year, 163 more cause numbers have been filed in Whatcom County Superior Court than through July of last year. And this office has taken in 190 more felony cases through July than we did in 2021. We have caseload standards that are imposed upon us by the Washington Supreme Court, so we don't have the unlimited ability to continue to absorb more and more cases. We have to cap ourselves at what the Supreme Court tells us we can take. And we are constantly battling that and have had to overflow some cases back to assigned counsel as a result of that. The other thing that's been difficult for us through the pandemic in particular is to get our lawyers qualified to take more serious cases, because qualifications are based on the number of trials that you had, and trials were kind of derailed for a couple of years in Superior Court and District Court. And so some of our young lawyers haven't been able to get into trial and to therefore get qualified. So the number of people in the office who are qualified to take homicides or other similar serious matters have really diminished, and it's becoming a small pool of people that get assigned difficult cases. So those are kind of the problems that we're dealing with, and I mention that because sort of the theme of what I wanted to talk about today relative to the jail is it seems to me that the problem is the same, whether it's the sheriff's deputies on the road or whether it's the corrections deputies, whether it's the size of the jail, whether it's the prosecutor's office and certainly our office. The problem is always numbers and whether the numbers can be controlled. And we're working hard to try and do what we can to keep not only our numbers down, but also other departments' numbers down, to the extent that that's possible. We have tried to incorporate some things into our office that are a little bit outside of the box or were at the time. Most notably, we added at the end of, I think it was 2018, a behavioral health specialist. And we now have a second behavioral health specialist. And these people are, I guess, what you would call a navigator or a facilitator. And their purpose primarily is to try and reduce incarceration rates and to find alternatives to incarceration for our clients. And that has a direct impact not only on us, but on the jail, obviously. We've made a pitch to the county in our budget going forward to add 2 more behavioral health specialists for a total of 4, which would very much enhance our ability, I believe, to reduce incarceration across the board. But I think that there's some other things that we could do to try and bring the numbers down as well. Maya and I have been looking at an outfit called Partners for Justice that contracts with public defender agencies to provide what they call client advocates to do much of the sort of quasi-social work that traditionally attorneys have done. And they are pitching to us that their success rate, excuse me, in bringing down incarceration rates and recidivism is pretty impressive. We haven't completely bought into that company at this point, but I think, Maya, if you can put the link in the chat room so other people can look at it, perhaps.
There is no chat, I realized, in this,
Oh,
but if you
okay.
Google Partners for Change, it pops right up, and they have a very accessible and clear website. Okay.
And we had a meeting with the director of Partners for Justice a week or so ago, and found their work to be very impressive. We feel that there are a lot of other things that we could do to bring incarceration rates down, and would also benefit our clients. I was just speaking with Jane a moment ago, and I wondered where community service work as a disposition in Superior Court had gone. For years, that was a very common disposition especially for first offense felony convictees, was rather than going to the jail as punishment, they were sentenced to some number of hours of community service work and given a period of time in which to do that. And for some reason, the prosecutor's office and the courts have moved away from that. But that's certainly a tool that could be used to bring down incarceration.
And I'll say COVID also had a huge impact on the ability to use that alternative.
Yeah, perhaps. But in any event, we're trying to think outside the box over here. And the reason I think that that's important is because I think under any scenario, the jail is years away, perhaps 4, maybe 5 years away, even under a best case scenario. And we all know that that the sheriff is looking for alternatives in terms of other jails outside of Whatcom County to house inmates in the short term until we can get a jail online, which has, really negative impacts on our office, because if our lawyers have to travel to see their clients in Snohomish County or Kittitas County or wherever they're going to be shipped, it's going to slow the court process down considerably and have a reverse effect on moving dispositions along through the system. So I think that really, in addition to the numbers being something important to consider in terms of the size of the jail that we build, certainly, and the type of jail that we build, certainly, there's an immediate need to bring the numbers down just to get us through this period of time prior to the jail coming on board. We have spoken, I think I spoke at a previous committee meeting briefly. Somebody asked a question about who can function or who is out there that functions as advocates for the inmates in the jail. And my response was that, in fact, we are the people that are best situated to advocate for our clients and to try and find alternatives to incarceration and programming and whatnot. And we think that it's important for us to be in the driver's seat on those types of activities, because what our clients tell us is protected by the rules of professional conduct and our confidential communications. We can't share that information with others or outside agencies. And the very first thing that we tell our clients when they're booked into the jail is don't talk to anybody except your lawyer or somebody that works for your lawyer. And so, to the extent that we have, a reentry specialist that work in the jail, and we have, people that provide services to people that are in the jail, they aren't covered by the attorney-client privilege. And I think that the effect of that, it tends to do one of two things. Either people won't disclose things that they otherwise would have because they've been told not to, or they disclose things that could be potentially damaging to their case or to their situation, because it's certainly conceivable that anyone that one of our clients talks to in the jail could end up being a witness against them in a case if they make an admission of some kind. And that's not a situation that we want to see proliferate. So what I've talked to Tyler Schroeder and Satpal Sidhu about is the possibility of bringing some of that work into our office so that it is more covered by the attorney-client privilege, and our clients are freer to share information that is important to be shared. And that gets back again to our request for additional behavioral health specialists and client advocates. And I guess we'll see how that pans out in the budget. I spoke to our behavioral health specialists about what they thought was important in terms of the new jail, if a new jail is built. And they gave me a laundry list of things that they feel would be significant and necessary in any type of facility, whether it's the existing jail or a new jail. And I think probably the number one request that they made is that they should have better and faster access to medical attention, including antipsychotic medication and that sort of thing. Usually when somebody is booked into the jail now, there's a considerable waiting period before they see jail medical staff, unless it's an emergency situation. Many of the people that get booked into the jail are on medication and can't get their medication until they see someone in the medical staff that can write a prescription, and then hopefully it's the right prescription that gets written. And meanwhile, the person who may need that medication is suffering in there until that need is met. And so we really feel that whether it's in the new facility or in the old facility, there needs to be some accommodation for faster and more efficient contact with medical personnel and prescription medication. There's programs that should be available in the jail that some of them used to be available in the jail, and many of them aren't anymore. Substance abuse treatment should be available in the jail, which means creating a space where that can happen and staffing someone who can provide that. There should be sober support meetings like NA and AA that people should be able to attend. There should be access to GED so that people can get some education when they're in there. You know, if they're sitting in there for 6 or 8 months, many of them could get a high school equivalency. Those are programs that used to be in the jail. It used to be in the classroom off the jail courtroom. And to my knowledge, they no longer exist in the jail for whatever reason. And so whether it's in a new facility or the old facility, there needs to be some allowance for those types of programs. We have one of our behavioral health specialists was a Department of Corrections, community corrections officer for, I think, 13 years before he came to work for us. And he suggested that there be some cognitive behavioral programs such as moral recognition therapy, which is what DOC uses on people that they're supervising. It's a 12-step workbook with group discussion, and they're open-ended, so you can come into the program at any time. You don't have to start from the beginning. We had a suggestion from the other behavioral health specialists that there should be dialectical behavior therapy, which I have to be honest with you, I'm not real familiar with, but I think it's a similar program to MRT. There could be parenting classes provided to people in the jail to assist them to, better parent when they get out, and perhaps prevent the next generation from being next generation's inmates. Anger management and domestic violence. I'm a member of the DV Commission, and I know that they are very concerned with getting people access at a low cost to anger management treatment and domestic violence treatment. And it seems to me that there should be some ability to provide that type of therapy and that type of treatment in the jail to those that are in there suffering from those types of problems. So those are the kind of things that we would like to see in a new facility. There are things that we think, are not inconceivable that they could be part of the old facility. But it needs two things. It needs space, and it needs a person to run those programs or to administrate those programs. And so that's what we would like to see. I guess my final comments before I turn things over to Maya here is going to be that, I understand that jail is punishment, and I think we all get that, and the purpose is to deter bad behavior, but it's also to rehabilitate people. The jail that we have here, in many instances, I think does people some significant damage, including those who come in with mental health issues that end up in really deplorable conditions. Without access, since COVID came in, to their friends or family to be able to come visit them in the jail. Many times they have very limited ability to contact people outside of the jail because there's a significant portion of the jail that's in what they call 23-1, which means they're in their cell 23 hours and they're out in the common area 1 hour a day. And so that 1 hour a day is the only hour that they can access a telephone to call their lawyer or to take a call from their lawyer, and to contact people outside the facility. And I don't know. I don't know totally why that is. That 23-1 has proliferated. It may be jail staffing. I know the jail has some significant staffing challenges. And it may be simply the design of the facility. Certainly, there are people that have to be isolated in the jail. There are people who are a danger to the other inmates, or there are people who are, so far off the tracks that they just can't be in population. And we get that over here. But our clients suffer in there, and that is particularly true for those who are suffering from mental disorders. It's certainly true for those who are found by an evaluator to not be competent to stand trial, and then have to wait an exhausting period of time before they can be transported to Western State Hospital for restoration. You see it over and over again that someone comes in with mental health issues, and in short order, they are worse off than when they came in, simply because of the conditions that they're in over there. So we definitely need, despite it being punishment, I guess we need a somewhat kinder and gentler facility that is not going to at least make people worse after they come in. And this is by no stretch a criticism of jail staff and Chief Jones. I mean, frankly, I can't imagine what we would be like without Chief Jones and her cooperation with this office, and giving us heads up about problems and giving us, feedback, and she's been invaluable. I think that it's more of a function of staffing and the physical facility itself. So I think as we go forward and try and envision a new jail, not only in terms of the size, but the type of facility it is, and how it can be less onerous, I guess, to those who are in there. I think that we should keep these things in mind as we move forward. I'm going to ask Maya now to talk about a couple things that we're concerned about with respect to the jail, and then I'll let Jane wrap it up with some comments about drug court, because that is a very significant program in terms of trying to turn the tide on numbers, as I said earlier.
Thanks. Hey, everybody. Well, I think we need to think about this new facility, hopefully through a lens of it being holistic and trauma informed, so that we can address the things that are bringing folks there in the first place. That access to medical attention in the jail is very poor. The timelines for seeing a mental health provider are far too long. People will go unmedicated or under-medicated or wrongly medicated for far too long. And it really makes it much worse. I know the jail is now providing medically assisted treatment for substance use disorders, which is a positive move. But I also hear from our clients that they're continuing to do balloon dosing of that due to lack of staffing. I've asked, I've tried to look into it, but I haven't gotten much response. And so I think that there's practices that are not meeting really the standards that should be in place that are due to lack of staffing. And that's just really unacceptable. And people are suffering because of it right now. Stark talked about 23-1, and you can imagine 23 hours spent alone in a small cell with 1 hour out, how destructive that would be, even for someone who isn't suffering from any level of mental illness. But certainly it has long lasting harm for those clients, that for all of our clients, regardless of whether they come in with mental health issues. So I think that's something that has to be addressed. It would be great to have more behavioral health help here in our office, client advocates. We could work to do higher quality, more in-depth early representation, working to try to get people out. We of course try to get people out on bail as it is, but without programming in place or services in place, it's much harder to convince a court or a prosecutor that it's a good idea to release someone. So if we can front load with that kind of help, I think we can be more successful in getting people placed in the community rather than in our jail. We have the mental health court, and we have that is housed in district court. We have an attorney who practices there, and our mental health court in Whatcom County is primarily used for felony reduction cases that are reduced to misdemeanors. And then those individuals are on a 2-year program in district court where they have supervision and intensive case management through mental health providers in the community. And that's fantastic. But there are limits to that program about who can be accepted depending on the nature of their charges. And if they're dual diagnosis, that's often a complication that prevents them from having access to the program, which a lot of our clients are. They have substance use disorder along with mental health disorders. And then the state instituted a new sentencing alternative, a mental health sentencing alternative recently, but we struggle with that one as well. You have to have a serious, what's called a serious mental illness in order to qualify for the program. And it will allow an individual to be placed on community custody through the Department of Corrections for 12 to 36 months, kind of depending on the nature of the charge that they had. But it requires that somebody, whether it's DOC or us, my office, to create a treatment plan with a community mental health provider. And that's where things get really sideways, because this legislation was passed to create this alternative, but nobody's in place to really do that work. We have our community providers who are already out there who are scrambling to try to provide this kind of service, but there's several hurdles. One, when our clients go into jail, they lose their Medicaid. So treatment agencies in the community are not going to come into the jail and meet with our clients for free. They won't do it. So there's no way to get them linked to their folks. There's one program, a very limited PACT program, that will go into the jail, but it's a very, very small number of folks who can utilize that program, and it's not adequate. I mean, we could use the program, I think, in a much broader way if there were funds to support it in community mental health to give treatment to our clients. So I think not only does our office need some more behavioral health help to link our clients, there has to be somewhere to link them to fundamentally. And I know that's kind of outside the scope of the SAC, but it's so integral. It's like, how do we reduce numbers? How do we have a reasonable and compassionate system? Without that, we really can't. I encourage you guys to look up Partners for Justice and see what they're about. We will keep pushing for that. I mean, our work has changed in our office since COVID happened for a variety of reasons. I mean, one that's not COVID related is that body cameras are now being used and have to be used in all jurisdictions, and soon will be in all, but mostly we get them from Bellingham and the sheriff. But last year we got about 430 some hours of body cam footage. And then this year at the end of August, we had over 1,000 hours already. And that's just because more agencies are using body cam, but that has changed our work because now we have to staff and process all of that discovery, all that information about a case. We can't ignore it. We have to look at it, and it's wonderful that it exists. I think it's really critical to justice, but it takes staff and person hours to process that. And y'all, I'm sure, are aware of the Blake decision that makes it so that we're no longer processing folks that are possessing controlled substances, but we're still seeing an increase in cases. Like Stark talked about, the first thing he mentioned was how we have, 160 more cases at the end of July than we did the year before. So case numbers are still going up, but the nature of the crimes is changing and the seriousness is changing. And that means it's a different kind of work. And Jane will talk about how that impacts drug court, and how that can be used as a program. But I think we have to be looking at things differently in order to staunch this flow of humans who are being housed in these really inhumane conditions at our jail currently. Thanks. I'll pass it to Jane.
Hi, I'm Jane Bowman. So I am the Senior Deputy Public Defender here, and I'm also the attorney for the Superior Court Drug Court, and I've been doing that since June of last year. This year, I just returned from the National Drug Court Conference, which is where we learn about the best practices in therapeutic programs like ours. And I attended that with the elected prosecutor, Eric Ritchie, as well as the judge for that court, Lee Grockmall, and some of the misdemeanor attorneys and commissioners and probation officers. So I'll tell you how we're trying to use that information in our program to implement best practices here. But first, if you're not familiar with our drug court, it is a pre-trial program in felony court, which means the participants are people charged with one or more felonies. They are not convicted. In exchange for being allowed to participate in the program, they compromise their trial rights. So they give up the right to have a jury trial where they would be able to dispute the charges, what witnesses said, challenge what really happened. And in exchange, they do this therapeutic program in which if they succeed, their criminal charges are dismissed with prejudice, which means that they cannot ever be brought back. If they are terminated, then in that case, they have a trial by the judge only based completely on the police reports. And based only on those reports, the judge makes a decision of whether they're guilty or not. And if they are terminated from the program, then they get sentenced. But it's a pre-trial program, so it's all accused people who are not convicted. Right now, our numbers in the drug court program are around 22 people. I think it is 22 people in the program. Before COVID, we had about high 50s. And so our numbers have taken a huge hit. We're rebuilding from a much smaller number and seeing more people getting in. I think for the purpose of what I have been asked to talk about, I will focus on two things that separate the drug court program from the traditional criminal legal system, which I actually usually referred to as a punishment system because that is almost our exclusive focus outside of therapeutic programs. Drug court is moving in the direction of almost never responding to drug use with jail. I can explain in a minute or in more detail how we use jail in some situations when someone does an act that compromises program integrity or violates rules that they are clearly able to not violate. But in response to drug use, whereas normal probation has always responded to that with jail time, our program really never uses jail for drug use alone. And I guess the related second thing is that we don't use a jail or prison fits all model to respond to participant behavior. So we use sanctions, which are punishments, but in combination with therapeutic responses to address participant behavior. We try to basically treat sick behavior, which is the drug controlled behavior, punish bad behavior, which is criminal conduct or behavior that threatens the continued effectiveness of drug court, and reward good behavior. So instead of jail, the sanctions in drug court take the form of community service, which Stark is right, I never see in the regular criminal process, but we use it as a sanction in drug court. We use work crew, which is a jail program. We use increased reporting to case management and the court because the drug court team is comprised of the drug court public defender, that's me, one prosecutor in the prosecutor's office, one judge who regularly always sees the participants. We have 3 case managers who I think are through Department of Health and the Superior Court, but Erica can correct me if I'm wrong. And then we have now a pretrial services officer who is developing a new place in the program. So again, a sanction can take the form of community service, work crew, increased reporting to that case management team or showing up more frequently for court hearings, all the way up to termination from the program and prosecution of the case. That's what happens if someone gets a DUI or a new felony charge in almost every situation. Therapeutic responses are things like essays, having to restart treatment or changing your level of care of treatment, get a new assessment, or return to a higher level of care like inpatient if someone is really struggling with their addiction, but they're not going to jail. And then incentives vary from applause from the court and all of the participants to coffee cards, recovery stickers, tokens, and ultimately graduation and dismissal of the criminal case. Okay, I'm going to skip a couple of things I was going to talk about, which might be more than is necessary here. Right now, we are reworking the petition and consent documents for drug court. Those are the documents that are used for prospective participants that explain the expectations and rules of the programs. And we're also reworking the policies and procedures to bring them in line with updates to best practices that have been developed in the last year. from the defender side, a lot of that work is trying to increase the census of our program by getting pressure on the prosecutor to reduce barriers to admission. So in Whatcom County, there are a lot of charges that are excluded from drug court that are not required to be excluded by the law that controls therapeutic courts. So there are a couple of things that mean a person cannot participate under the law, but there are a lot of things that are technically eligible for participation in a therapeutic program that are nevertheless excluded by our prosecutor's office, because the law does require in Washington that the prosecutor hold the keys. They are the gatekeepers. If they choose for any reason to say a person cannot participate, that is the end of that person's chance of doing drug court. So a lot of the work that I'm doing right now in my role as we rework all of these documents related to admission is trying to persuade the prosecutors, including Mr. Ritchie, who did go to that training, that best practices lets in more people who are high risk, high needs. High risk not meaning high violence, but meaning higher likelihood of repeat offenses, because those are the people who don't respond as well to prison, who've tried it and that didn't work, and who instead should have something different tried this time. Therapeutic programs pay off. There is not good data right now because of COVID on what's happening in drug courts in the past few years, but it's certainly, recidivism certainly appears much lower for people who participate and complete a drug court than a traditional prosecution involving going to prison. I have some statistics that I can certainly share if there's a way for me to do that after, but Whatcom County has lower recidivism for felonies and violent offenses for people who graduate our drug court than across Washington. Generally, we have better statistics in our program than elsewhere in Washington. We have slightly higher recidivism, a couple percentage points for what they call any crime, but that does not include felonies or violent felonies. So I can't say what exactly falls in that category, but we have a very good and robust program with a lot to offer here. We are pretty homogenous racially. We have 85% white non-Hispanic participants as compared to 66% statewide. So we have a much more homogenous population in our program. And although this doesn't mean I don't exactly know how to interpret this statistic, but others might, we have more people enrolled in Medicaid who complete our program than the state average. So to the extent that's a metric of our success, we're getting a lot more people into that program than elsewhere. So I would love to answer questions about the program. I'm trying to stay general, but certainly it is I would say the best, most supportive diversion program with the highest likelihood of avoiding people ending up right back in jail. And we are not, although we sometimes hold people while they wait for treatment, we are otherwise basically not using the jail, even though we're dealing with an exclusively felony population.
Okay, if I could just make a couple final comments about the jail as it is and as it should be, because again, I think that's the primary focus of this committee. There are some good things about the jail as it currently exists, and I understand that the public defender's office is, just one of the many oars in the water here, but probably the best thing about the jail for us is that it's across the street. It's not in Snohomish County. It's not out in Ferndale. It's not somewhere. It's not even out in Iron Gate. Those are people don't perhaps think about the obstacle that it creates when you have to get in your car and drive somewhere to see your client, as opposed to just walking across the street. And that has been a concern of mine, basically, since I think the first proposal for a jail out in Ferndale was made, that would be an added difficulty. It is a difficulty for us to go to the work center in Iron Gate. For a 15 or 20-minute conversation with your client, you're out of the office for an hour in order to go out there, and it would be more significant certainly going to Ferndale or somewhere else. The other good thing about
I just wanted to interject to say location is also important, because we think it's important that our clients appear in court in person and not by video. It is, you cannot appreciate the humanity of someone in this setting. It's not the same, you know, and when someone's being sentenced or someone's entering a plea of guilty or someone's having a significant motion in their case, we want them in the courtroom, not appearing by video. And the distance, I think, would only make it more likely that we go down a road like that. Thanks.
I agree with that. Thank you, Maya. The other thing that is good about the current jail is that I can pick up my telephone and call in and talk to most of my clients over the telephone without having to walk across the street. That's not the case with the 23-1 population, but for those who are in general population, they are most of the time available for a telephone call. IT in the jail has also set up video conferencing for us in there. We call it CAL, where inmates can be pulled out of their cell, put in a private booth, and we can see them on our computer screen and converse with them. And those are all positive things. However, the telephone and video conferencing are no substitute for face-to-face conversations with your client. You have to be able to do that for them to trust you, for them to take your advice, for them to, for them to be humanized. They have to have some degree of face-to-face contact with their lawyers. One of our real hindrances right now is that we only really have one pass-through conference room in the jail for clients. We have, well, I guess there's two if you count the glass one on the first floor. We used to have two conference rooms, but the jail had to close one of them because of the problems with the elevators in the jail. And I'm a traditionalist. When I want to talk to my client, I like to go to the jail and I like to sit in a room with my client and talk to them. And I try to stay away from the video conferencing and the telephone conversations to the extent possible. But when a new jail gets built, wherever it is, there needs to be some consideration to expanding the number of visiting rooms that lawyers can have to access their clients, and some thought to the ease with which we can get in and out of the jail. The way we meet with our clients now is we go to the jail, they send us up to the visiting room, and we wait sometimes 5 minutes, sometimes 20 minutes, sometimes a half an hour for them to bring the inmate to the booth. And then we're locked in the booth with the inmate. And when we're done, we ring a buzzer and we wait sometimes 5 minutes, sometimes 20 minutes, sometimes a half an hour for staff to come and remove the inmate from the visiting room and let us out of there. So there's a process, I think, that could be more efficient. It may not be possible in the facility as it exists now, but we have a very strong interest in access to our clients in the new facility. And so, thought needs to be put into what that's going to look like and how it can be made easier and available to more people. So those are, I think, the comments from the Public Defender's Office. And any of you have any questions for any of the three of us?
Okay, thanks a lot, Stark and Maya and Jane, for being here today. So questions, please use your raise hand icon. It's much easier to track you. Arlene?
Thank you. That was a really great presentation, filled with really important truths and all the things that need to change and be better. And thank you for it. At the same time, it's my understanding that some of the problems also come from public defenders. And the reason I say this is because there are other people who have done intervention work with the people who are charged. And that is what they say some of the time. That is to say, some of the attorneys do not spend enough time giving information to their clients. Sometimes they give poor advice. And so I wonder if it's best to put the navigators into your department, or to have it be, a separate entity that's doing that work, more objective.
Well, my response to that is that my staff here, particularly my attorneys, are the most knowledgeable and the best trained criminal defense attorneys in Whatcom County. And we are routinely contacted by the private bar to ask us questions about how to do things, which is not to say that we don't have dissatisfied clients, and which is not to say that mistakes can't be made when they are brought to our attention, either Maya's or mine. We explore that problem. We talk to the lawyer about it. We encourage corrective behavior if necessary. I would say about 99% of the complaints that we get are lack of communication. You know, if somebody's been sitting in the jail and they haven't seen their lawyer in a couple of weeks, they get frustrated and they complain about it. You know, so I don't really see that the public defender's office is any different than any other organization, that there are people that might not be happy with what we do or when we do it. But to the extent that we can, we root out those problems and address them as quickly as possible. The bringing of navigators or advocates under our roof is simply a function of the need for confidentiality. And we've had situations where our clients have talked to Lifeline or to the reentry specialist in the jail or others, and information gets in an email and it gets forwarded to 4 or 5 different people, and all of a sudden whatever our client has told them has, you know, been disseminated, you know, well beyond where we would have been comfortable with having that information disseminated. So that's my pitch for bringing it under my roof. You know, and I think, you know, to some extent your question is a valid one. You know, but I really think that we have a high quality organization here, and I do think if what you want are people to advocate and navigate for our clients, we are the ones in the best position to do it.
Thanks, Stark. David?
2 questions. One of them is probably very quick, but if somebody does not qualify for a public defender, would they still have access to the public defender's navigators and advocates and things like that? Or is that only if you know, qualify? The second question is, and this is maybe for later, I would love, I mean, there's years and years and years of experience among the 3 of you and, you know, your team. And I don't mean to by any means make things about money, but we're here to also be concerned about the finances of the community, et cetera. I'm wondering if we could get sort of an estimate from you all about which programs, if you had $500,000 or $1 million to throw at programs that divert, that would reduce your loads, that would reduce the jail loads, where would you spend that? And if we could gain that information from you and the rest of your team, I bet that would be very valuable.
Maya, you want to answer that one?
So we could just get, if we had $500,000 extra added to our budget, what would we do?
From the county, you know, just to put it something that would divert.
Right. Well, I mean, I think right now thinking about these client advocates is great. I mean, we have more, we are finding ourselves, because of attrition and because of the increased filings and because of sort of slowing down of trials, which although trials have resumed, there aren't 4 courtrooms available for trials every week. That's reduced. I don't know. I always feel like we can always use more legal staff, and I don't know. Like that's, I guess, where I would put it. I think in behavioral health stuff. Jane looks like she wants to comment.
Well, I would say the place that we are jammed up, that is completely out of control, is with people who are mentally ill in jail. And so we have, like, I just got for someone who's been in custody for a couple of months, an estimated bed date in March for hospitalization. They say he's treatable and he is going to be in jail with 0 progress toward the resolution of his case, getting worse and worse and worse and worse every single day. in March if the case is not dismissed. And this is a serious case. And so my comment would be the jam ups that I see are all with mental health services. And so that's where I think the resources would need to go in our office, as someone who can help navigate programs like MOSA that Maya was talking about, and the mental health sentencing alternative that's new.
But people have to be competent to do those programs.
They do it. That's
As
true.
Jane, as
That's
Jane
true.
well knows, and I just say that for the benefit of everyone else, but I mean, like, I mean, could the county build a facility that is not our jail that could house folks waiting to go to the hospital? I mean, there shouldn't be months-long waits. It's horrific, but could there be some specialized facility where they are actually getting mental health care, and maybe they rehabilitate, maybe they recompensate themselves just through getting adequate mental health care in our community? So like, maybe that's a different facility from the jail. That's like an interim place while a new jail is being built.
I think my personal philosophy is let's try something different than simply growing this office to accommodate more and more defendants. Let's try and figure out a way to bring the number of defendants down, because that helps everybody. And you know, although I'm kind of an old dog, I'm willing to try some new things. And you know, this idea of these client advocates or behavioral health specialists or people like that didn't used to be an arrow in my quiver, I now have, and I'd like to use them to see if we can turn the tide on the numbers. You know, otherwise this office is just going to get larger and larger as the population grows, and nobody's going to be happy with that, and that's certainly not my goal.
Peter.
Can you hear me okay?
Yep.
Okay, great. Well, I've got 4 questions, but there's not time for them, so I'll just keep to one. Stark, you were concerned about jail location. If, let's just say it's in Iron Gate, have you seen other models in other communities where you have a satellite office or something that would resolve your concerns that do keep coming up in my conversations with many people about jail location? And I don't want to just make an assumption that it has to be downtown because of what you've just said. I am curious if you have seen other communities, how they do it. Surely it's done elsewhere.
Well, Skagit County built a remote location, although it's not all that remote. It's down south of Anderson Road in South Mount Vernon. And from where the public defender's office down there, because they don't have a building that can accommodate their entire office, I think they have 3 locations, but they're all about, I don't know, a 5-minute drive maybe away from the jail. Jane, maybe you know the answer to this, and you could just nod if you do. Does the King County Public Defender System have offices down at the Kent Detention Center? Do you know? Yes. So there's an example of, you know, I think that the King County Public Defender's got something in the neighborhood of, I don't know, 250 or slightly more lawyers in their office. And most of those lawyers are in downtown Seattle, but a large number of the inmates are in the South King County Detention Center, which is kind of down in the Kent area. And if you can imagine what that would be like to have an office in downtown Seattle and have to drive to Kent to see your client. I don't know of any other offices like that. I think most jails traditionally were built in a central location, but, you know, obviously times have changed and the availability of property and all that might not accommodate that. There's certainly no reason why we couldn't move to a different location closer to the jail. But then it would have the problem of being away from the courthouse and away from other things. And, you know, none of this is insurmountable. It just all adds to the problem. And like I said, if a 20-minute conversation with a client turns into an hour-and-a-half ordeal, it's not efficient. That's my view.
Ralph? Rel, you there?
Sorry, I was having
No problem.
sorry, trouble muting. Thank you. I really appreciate all of this information. So many questions, but I'll just keep it to a couple. with the increase or with the drug court, you were saying that there's like certain kinds of cases that are not allowed by the state, but there are a number of cases that are allowed by the state that aren't being allowed into our drug court. And like, would it be possible for you to give us some like averages or numbers of like what the increased capacity could be in a hypothetical way that would be in keeping with state regulations on drug court? But is that possible to get that?
No, I think what I could certainly share after the fact is the cite to the statute that defines what's allowed in, and then what the eligibility criteria are. What are the exclusion criteria that our prosecutor's office uses, so that you can compare those with each other. In terms of the number of people who could be allowed in, I think I would need to talk to our changing case managers, because we just hired a new coordinator who's going to be taking over. But I think that program can accommodate around 60. Don't quote me on that, but we are well below our capacity. So there were sort of two parts. How many, Stark said at the beginning how many felonies our office manages. A huge number of those that could go into the drug court program are either denied or don't make sense for one reason or another that would take a longer time to explain. But we certainly have capacity for more people, and we certainly have people who we consider eligible who are excluded. And I could share the exclusion criteria that you could compare with the statute. I hope that answered the question. Let me know if not.
Sort of, yeah. So I understand. So 60 is what the capacity is of the program. But like, let's say in a world where that program was expanded in order to meet the need based on state, regulations or statutes or whatever, like how big would that program, let's say, for example, that the prosecutors or whatever are the reasons why those cases aren't being allowed, like those didn't exist anymore. Like what would be the number that would be an ideal size to accommodate,
I think the court could easily hire additional case managers. I think they haven't had the number of participants to bring on new staff, new case managers. And so I think the program could easily grow to accommodate a much larger number of people with additional court calendars. I don't think there's like a number limit that we would hit that would become impractical. We have a court lasts about 1 hour on Thursdays afternoons. It previously went from, instead of 2:30 to 3:30, it sometimes went until 5. That could happen again. And we could find additional times, I think, in the court calendar if the program became that robust.
Okay, thanks. And then just 2 more questions. One is, like, in your opinion, do you think there is enough local capacity in this area to house all the needs for inpatient treatment that there are in drug court, or just in general, like just from your experience working in drug court? Like, is inpatient beds, is that an issue at all?
Well, there is one inpatient, it's called a low intensity residential treatment center. It's new in Whatcom County. It opened this year. It certainly has capacity that is not being used because it offers, I think Maya wants to add something. Well, that's our only inpatient program in Whatcom. There are beds open.
We're able to pretty quickly get inpatient beds for our clients who can use them, or not that can use them, but where it fits sort of with their case, where we can make it work. But I think that I think that it's maybe more like sober living situations after release from inpatient, I would say, is probably the biggest gap that I would identify. Like there are outpatient programs here in Whatcom, but then like where does someone go live when they get out of inpatient to a stable situation? Like that's Jane, do you?
Well, I would challenge that we have enough, that we're getting super quick turnaround for inpatient programs. We can usually get someone in within about a month in the drug court program, sometimes much sooner, sometimes it can be within a week or two.
Yeah,
A challenge that we have is I think there's only one evaluator from Whatcom Detox who actually goes in for our program to do in custody assessments. So getting people who need treatment assessed in order to make those referrals to inpatient can cause delay. But in terms of what I think you were asking about, the number of inpatient beds in Whatcom County, we have one inpatient program. It's not the highest level residential facility. It's called, I think, level 3.1 or 3.3. It's a low intensity men only residential treatment center. It's sort of like a in between from outpatient care and
Right.
highest level of inpatient.
Okay, thanks. I have a couple more questions, but I'll let other people ask. Yeah, thank you so much.
Okay, since we're at our final time, we're going to let Dan ask his question, and then I'm going to encourage anyone that has further questions to send them to Kathy Halka and our SAC, kind of our intake email address, and we will make sure that you get those answers to those questions. We'll send them on to Stark. So Dan?
Thank you. Sorry, I'm on my phone here in a busy hotel lobby. Apologize for the background noise. So this issue of restoration keeps coming up. And it seems like it's this delay that Jane was talking about in terms of waiting till March for one of her clients. Just seems like it does nobody any good. It doesn't do the client any good. It takes up a bed in the jail, which affects booking restrictions with all jurisdictions that use that facility. So I guess my question is for the lawyers is there's been a conversation here on the Incarceration Prevention and Reduction Task Force about a mental health hospital. And while that sounds like a big expenditure and very expensive, I'm wondering if a smaller facility could be built. I think it's to Maya's, I believe, earlier point, if that's even a legal thing for restoration services to be provided locally. So we take the middleman out, we take Western State out, and we do it locally here. Is that even possible?
I don't know if that's possible under the statute. I don't know the answer to that offhand, but that delay, could certainly be alleviated if Western State and Eastern State were expanded. And probably I'm the only one on this that remembers Northern State Hospital in Cedro-Woolley. That was a place that these folks went to before. They closed that down, and no alternative was ever constructed. But the statute makes reference to the hospital or a state hospital, I believe. And, I think that would become somewhat problematic for a local organization to open a hospital to do restorations. I just don't know whether that would be legally permissible. I would say that, Maya and I have both met with some of the politicians that are running for office this fall, and we've addressed this issue of the delay in restoration with both of the candidates that we met with. I think it's a function of staffing at Western State. It's a function of beds at Western State. And the legislature simply has to get off the dime and expand Western State to the point where these people don't have to have these unreasonable delays. And I want to add that they're not just unreasonable delays; they're illegal delays, because the statute gives Western State a timeline with which to get these people down to the hospital, and they just ignore the timeline, and they're having contempt sanctions imposed against them, and in some cases dismissed when they aren't in compliance with the timeline. Jane has had several felony cases dismissed because Western State simply delayed the restoration process for an illegal and unreasonable period of time. So I don't know if a local alternative is the answer. Barry and I were meeting about this issue some time back, and I think my comment to him is the only thing that's going to solve the problem is a lawsuit against the state. And
well, much like we talked about our not wanting our system to just grow. I mean, they can expand Western. They are, I think, building another building at Western. I don't think that's gonna. I don't know how long that will have any positive effect in reducing the numbers or the waits. or when that will actually happen. But for to say that a local facility may not be able to provide restoration services under the statute, but to say that, oh, locally, we're going to take these folks that are awaiting restoration and provide them with intensive services. I think we, in many cases, would see folks be restored to competency in a therapeutic setting. Absolutely. Like there are some that will never be restored. Doesn't matter where they are. There are some that maybe will need services that aren't available at that. But I think some large number of them would actually be restored to competency, even if it's not officially the restoration process, and that we can intervene if someone is restored and we communicate with them and we're like, oh, wait, their situation has changed. Competency is a fluid concept, and we can ask for another evaluation at any point. And if that person has restored through therapeutic means in a local setting, then we could bring them back and start their case again. We wouldn't have to wait for them to go to Western. So I do think that it has potential, maybe not officially, but like it's a community choice.
Okay, folks, it's a little after 2 now. I just want to thank everybody for being here. Thank you, Stark and Maya and Jane, for all your great information you gave us today. It really helps set some more context for our work in the SAC. So without any other business before us, I think we will adjourn, and everybody have a great weekend, and we'll see you all next week, next Thursday at our meeting for facilities. So we're adjourned.